Intoxication assault. What is the law in Texas? If you or a loved one are facing a charge of intoxication assault, what does the state have to prove, and what are your possible defenses? Hi, I'm Jeff Hampton with the Fulgham Law Firm, and I want to welcome you to our YouTube channel. Today, I'm going to spend a few minutes talking about the charge of intoxication assault and making sure that you have a general understanding of what the law is and what the prosecutor must prove beyond a reasonable doubt. By the way, if you wait around to the end of this video, I'll also give you a free ebook, The Ultimate Guide to Your DWI Defense in Texas. Okay, let's jump into this. Now, what is intoxication assault? Now, I'm going to give you a little bit of basic information just as I would if this were a DWI video, because some of the same DWI laws apply to intoxication assault because the law is a little bit transferable in terms of its application. So anytime you have an intoxication assault charge, just as a DWI, the first thing you need to recognize is that there's two parts to your charge. One is the civil or administrative side regarding your driver's license. Number two is the aspect of your criminal case itself. So just as a reminder, you have 15 days from the date of your arrest to request a license hearing. If you do not request a license hearing, your license will automatically be suspended 40 days after the date of your arrest. So under Texas law, there's something called the implied consent law, which means if you are investigated for a DWI or an intoxication assault, you impliedly consent to give a sample of your breath or blood. And so this aspect of it, when the officer pulled you or your family member over, went through all of this, once you were arrested, they should have given you a statutory warning form asking you for a sample of your breath or blood. If you don't contest that part of this, of the civil side of that, of your charge through DPS, your license is going to be suspended. So don't miss the 15-day deadline, all right? Now, the second part, which is we want to talk about here, is the criminal case. How does your actual the intoxication assault charge, how does it have to be proven under Texas law? So under Texas Penal Code defines intoxication assault as follows. A person commits an offense if the person, by accident or mistake, while operating an aircraft, watercraft, or amusement ride while intoxicated, or while operating a motor vehicle in a public place while intoxicated, by reason of that intoxication causes serious bodily injury to another. Now, here are some big things that I know I said that very quickly, but here's some main highlights that grab our attention as we go through the definition of the penal code. Number one, that when you're first looking at this, the state of Texas must prove serious bodily injury, okay? So it can't just be a car accident where somebody got hurt. They actually must prove beyond a reasonable doubt that the car accident caused serious bodily injury. The intoxication assault also must also be that your intoxication was the cause of that injury. So first, you've got serious bodily injury. Second, you've got to be able to prove causation, that your intoxication was the cause of that injury. And then claiming that you were negligent or did not intend to hurt someone, that doesn't provide you defense. There is no criminal intent element to this, okay? But they still must prove the elements of intoxication, just like on a DWI. So we're going to break that down and go over some of this. Now, a few things first. What are the penalties for an intoxication assault charge in Texas? Under Texas law, DWI may be labeled as a misdemeanor charge, but under Texas law, intoxication assault is elevated up to a felony charge, and it's actually a third-degree felony, punishable by a minimum of 2 years, up to 10 years in prison, and up to a $10,000 fine. So the main difference between an intoxication assault and an intoxication manslaughter case is obviously a manslaughter case is basically a DWI where someone dies. An intoxication assault charge is a DWI where someone is seriously injured, as defined by the penal code, okay? Now, let me just give you a few things. First of all, it's important that whoever you decide to work with as your DWI attorney, your intoxication assault attorney, they need to really go over all the evidence. They need to collect and document everything to build a solid defense for your case. Because remember, even though you do not have the burden to prove anything under the Constitution, the state of Texas is going to take everything that police officer said, any other witnesses said, they're going to just take it as being the truth, the gospel truth. That's how they're going to interpret it. So it's very important that we know the prosecutors are going to gather all the evidence that they can. Your defense attorney needs to make sure and gather evidence from you. That also involves you going over those police reports. It involves you thoroughly going over the information and all the evidence, your videos, everything, to make sure what is accurate and what is inaccurate. So we're going to go over a couple of the common defense strategies related to intoxication, because the first thing they got to prove, look, car accidents happen every day. People get killed in car accidents. People get injured in car accidents. But the state of Texas must prove that you were intoxicated in order for this to be a crime when you're talking about intoxication assault. So how does the state prove intoxication? Essentially 3 ways. One, we know the most common one is to be at a .08 or higher at the time of driving. That's one, is the .08 language, right? And that is essentially based upon a breath test or a blood test, and we'll get into that here in a minute. The other is to have lost the normal use of your mental faculties due to alcohol or a drug, or to have lost the normal use of your physical faculties due to alcohol or a drug, okay? And so those are 3 different ways that the state of Texas can prove it. Here's the thing. The first 2 are opinions. When you start talking about mental faculties, physical faculties, that's very much an opinion. So I can guarantee you that the police are going to be pushing to get a good sample of a breath or blood test in order to be able to establish true intoxication for your case. Now, some of the defense strategies that your attorney really needs to be looking into first is, number 1, if there was a breath or blood test, was the breath test administered properly? Usually nowadays, most of the time, they're going to be trying to get a blood test from you. So in that situation, was the blood drawn properly? Was the chain of custody established? Did the lab do the testing properly? Was there something else involved other than alcohol? Was there prescription medication involved? Was there marijuana involved? Some other controlled substance involved? So there can be other factors that influence whether or not someone is intoxicated. It's not always just as clear as having a particular number, okay? And so, and then beyond that, we're going to talk a little bit as well. We're going to dig into some of the other defenses related to serious bodily injury and causation. But it's really important to understand, just because someone was injured does not necessarily mean it's automatically an intoxication assault. The state still must prove the elements of DWI, which is you operated a vehicle in a public place, and it had to be in a particular county, right? And that you were intoxicated at the time of operating that vehicle, all right? So that's very important that those have to be proven. Now let's talk about this for a second. When we talk specifically about challenging intoxication, let's talk for a few moments about a blood test. What if the time that the blood was taken, did the person who take the blood, were they a qualified technician? And these are some questions that need to be answered. You need to make sure, was it a nurse? Was it a qualified technician who was able to do the blood draw? Was the site on your arm or where they drew the blood, was it contaminated? Did they use a betadine swab? Did they use an alcohol swab? Was there a failure to properly mix the blood sample with the preservative and the anticoagulant that's required under the law? If the blood sample was not handled properly, what if it was exposed to heat? What if the actual vial was not sealed properly? If it was not sealed properly, a byproduct of the decomposition of that blood is going to be alcohol presence within the blood. Also, did the lab handle things properly? Was the lab properly? Did they follow the sanitization standards required under the law? Did they improperly function? Did the lab equipment properly function like it's supposed to do? Did the blood sample get labeled properly? Was it mislabeled? We find human error that takes place in blood samples quite frequently. So there's a lot of things that needs to be looked into as it relates specifically to a blood test. Okay, now let's talk about the next point. And these are just highlights, but these are points that your attorney needs to go through. Number 2, what about challenging causation? Remember, your intoxication, being intoxicated, must be the cause of those injuries. So there are 2 aspects of causations that are relevant in defending this type of case. The first type of causation concerns the driving conduct that led to the collision. What if you were not the cause of the actual collision itself? Even if you were involved in a crash while you were driving while intoxicated, it does not necessarily mean that you were the cause of that crash. So one of the things we have to look at is look at a car accident, a reconstruction report. Every time there's a car accident, the police are supposed to put together an actual accident report that outlines who the cause of it, the cause of the wreck, and exactly what took place. That needs to be analyzed thoroughly. And so there may be a civil lawsuit that may be involved in that situation, but it doesn't necessarily mean there should be a criminal suit involved if you were not the actual cause of the accident. And even if you were the cause, was the intoxication the cause? I'm going to give you an example. We had a case one time where someone was actually driving and they were intoxicated, but the other driver or the other person, the alleged victim involved in this, they were not paying attention. And because they were not paying attention, they were on their cell phone. They veered over into partial lane of traffic where our client was driving. And as a result of that, that you could not have an accident construction expert ever say that the other individual was not a major part of the cause of that accident. In other words, here's the inquiry. Would the accident have occurred? Could it have occurred regardless of the intoxication of the individual, right? If so, they don't have a case. You might have a DWI case, but you do not have an intoxication assault case, okay? So we have been able to have instances like this where when causation is a concern, where one of the ways to resolve the case is to have that intoxication assault felony lowered, dropped down to a misdemeanor DWI charge, which makes it much easier to resolve and get off someone's record in the future, okay? Now, number 3, what about serious bodily injury? Many people make the mistake of presuming that they will not be charged for intoxication assault because they weren't arrested at the scene of the collision. This happens a lot, where sometimes something will happen and there's not exactly sure what's going on, and then what happens is later they discover there was a serious bodily injury that ends up taking place. Someone ends up getting transported to the hospital, or someone ends up later on determining that there was an injury that happened to the alleged victim. So one of the things we need to do is define what is serious bodily injury. So under the code, when it comes to criminal matters, serious bodily injury is a permanent loss of use or a protracted loss of use of a bodily member or organ. Now, what does that mean? That means crippled, loss of eyesight, loss of hearing. What if we talk about something where now maybe a permanent disfigurement? We're not talking about a broken nose. We're not talking about bruising or just pain. That's different. That's bodily injury. It's not serious bodily injury. So it's really important. What if there is a car accident? What if someone is intoxicated, but the state of Texas cannot prove a permanent loss of use or a protracted loss of use of a bodily member or organ? Well, now you don't have a felony, you have a misdemeanor. And let me just say this is one of the areas where these elements of the crime must be attacked at the grand jury level. So one of the best places to get rid of a felony case in Texas is at the grand jury, because a grand jury is a requirement under the Texas Constitution. Every felony must be presented for indictment at the grand jury. And what it essentially is it is a filtering stage. So the grand jury is supposed to allow certain cases through that are good cases supported by probable cause. But they also have the option of dropping the charge down to a lesser charge, from a felony down to a misdemeanor, or they can do what's called no bill the case if there's insufficient evidence at all. Now, here's the problem. Most criminal defense attorneys, most DWI attorneys, don't present evidence to the grand jury for the grand jury to consider other alternatives. So your attorney really needs to get out in front of this and take a look at it early to provide an opportunity that may be some evidence that would show that you either did not commit this crime, or maybe it's being charged wrong. That information could be presented to a grand jury to possibly lower the charge or no bill the case altogether. Okay, so these are just some examples of some things that we're looking at here. And here's the thing, the reality of it is these are very serious charges. Okay, it's much more serious than just a DWI, because if you're facing this or a loved one is facing this, someone ended up going to the hospital. Someone ended up getting pretty seriously injured. And I can promise you this, the district attorney's offices throughout the state of Texas take these types of charges very seriously. So in many ways, you're on the clock. It's very important that you find an attorney that you trust and can help you through this process. Okay, now listen, I hope this video was of an assistance to you. I hope it gave you a little bit of a background of the law in Texas related to intoxication assault. If you or a loved one are facing a charge like this in the North Texas area, feel free to give us a call. You see the number that's above me here on the screen. It's been up here the entire time. I encourage you, give it a call. We'll be happy to give you a free case analysis and a consultation. And I also promised you a free ebook, The Ultimate Guide to Your DWI Defense in Texas. All you have to do is click the link below into the YouTube section below where all the script is down there, and you'll see an opportunity for you to be able to receive a free ebook that gives you your ultimate guide to your DWI defense. I want to thank you for joining us here on our YouTube channel. If you like what you heard, subscribe, and we'll send you more great content like this, and we'll see you on our next video series.